Welcome everybody. I'm Kevin Johnson, Dean of the Law School here. And today we have the latest installment of the UC Davis School of Law Racial Justice Speaker Series. This is the third year of the series, which we initiated after the national controversy over the killing of George Floyd in Minnesota. And the series has looked at racial justice in the United States generally, from criminal law to immigration law to corporate governance to national security to family law and more. And one of the points of the series is that racial justice weaves itself throughout U.S. society and it affects a wide number of different groups. Now, we're very lucky today to have returning, briefly, Professor Rose Cuison-Villazor, who teaches, researches, and writes in the areas of immigration citizenship law, Asian Americans in the law, equal protection law, and critical race theory. Her research agenda explores legal structures and systems that determine membership and sense of belonging in the United States. She's an expert in immigration, citizenship, property law, and race and law. She is the founder of the Rutgers Center for Immigration Law, Policy, and Justice. And at Rutgers, she is the interim dean of the Newark campus of Rutgers Law School. She's working on not just one, but two book projects, one on Asian Pacific Americans in the law, and the other on property law and race. A few years ago, she was a professor of law and Martin Luther King Jr. research scholar at UC Davis School of Law. She has a bachelor's from the University of Texas, an LLM from Columbia, as well as a JD from America. Today she's going to talk about revisiting Downs versus Bidwell. And as you'll hear, it's a very relevant case dealing with Puerto Rico, which was in the news over the weekend, as is the constitutional protections offered under Downs versus Bidwell. Please welcome Rose Villazor.
Thank you, Dean Johnson, for that warm introduction. Thank you, everybody, for being here. It is so lovely to be back here at King Hall. I think about King Hall all the time when in the work that I do, particularly as a dean right now. I think often of Dean Johnson, Dean Afra Afsharipour, and all my colleagues here who have helped to really create this law school to be the really strong law school and a model for racial justice. And so I'm really happy to be here, to have been invited to come back to talk about a project that is really in the beginning stage. Or I should qualify that. I should say I'm returning to the beginning stage of this project. It's that the project, as you can see here, is on rewriting Downs versus Bidwell. Let me just give you an outline of what I'm going to be talking about today, with a big caveat that we really are at the very early stage of this project. I am and some of my research assistants are dusting off a project that I started when I was still here at King Hall. And so let me just share with you this book project that Dean Johnson and I were involved in, and it was on rewriting Supreme Court opinions, critical race judgments. And in that book project that was co-edited by Dean Angelo Wanchawillig, Professor Devin Carbado, Professor Bennett Capers, and Robin Lenhart at Fordham Law School. That project, as you'll see in a few slides later, examined how critical race theorists can possibly rewrite Supreme Court opinions and try to take and remove racial subordination from the opinions. I was invited to write this for that project. This was in 2016. And so what you'll see, some of the work that I started doing back then. But then President Trump was elected, and I didn't feel right, at the time anyway, using this project, using this case, Downs versus Bidwell, as a mode of looking into where race fits in. At that time, I really wanted to focus on immigration and race. And so I asked if I could rewrite Che Chang-ping versus United States, and that's what appeared in the book that was finally published last year. Dean Johnson was one of the other contributors there, and there are a lot of other contributors. So I wrote a draft of this paper, and I actually presented it years ago, and some of the professors in the room might remember, so sorry. There's not a whole lot of new thing, but it's good to see you. And those of you online, also good to see you. I was invited by Fordham Law Review to participate in a symposium next month on the insular cases. And so I thought, rather than writing a whole new law review article, why don't I dust off this project? And so you get to see the beginning of the project that I hope will end very soon, because I do have to submit a draft. So for today, I'm going to give you a background or context for this project in particular, and then explain the methodological approach of rewriting Supreme Court opinions, why I believe that's an important project to begin with, and that's the overarching framework for this particular article. Then I'll talk about why Downs versus Bidwell makes sense to examine from this new lens, a new pedagogical approach and scholarly approach of thinking about Supreme Court opinions. And what my thoughts are about what a rewritten opinion might look like. And then if we have time, I'll talk about how it applies to this case study of Fidesamanu versus United States, which is there's a cert to the United States Supreme Court, and hopefully they'll take up the case. We actually want the court to take up the case. Okay, so just some quick background and context for the project. As Dean Johnson mentioned, among the areas of my research interests are citizenship and race. And so I've written also in other areas, but for today's talk, this particular paper fits in within my overall interest in examining how the United States has defined citizenship, who belongs, who does not belong, what is the Supreme Court's role in defining membership and belonging. I'm one of, I didn't update my bio, but my more recent case book is on race and racist with Juan Pereira and Richard Delgado, and it's often used in critical race studies cases, and so some parts of this project appear in that forthcoming book. Another reason, or another, in my mind, an important background for this project is a personal one. I was born in the Philippines, and I was raised in the Commonwealth of the Northern Mariana Islands. Much of my writing is impacted by my own experience, and these two were U.S. One was a U.S. territory, the Philippines, and the CNMI is still a U.S. territory, and so I wanted to make sure, I wanted to see or continue to examine how racial construction has taken place in these territories historically and as well as today. And so these are just some of the citations to other articles that I've written in this area. My most recent one is Rejecting Citizenship. I did a book review of a book by Professor Ming Chen, and I introduced some of the concepts that I'll be talking about today. Okay, the last background context for this project. The ABA recently changed the standard for 303. And I think it's important to pause and explain why I think my project and other projects fit in within the ABA 303. So now ABA 303 says, law school shall offer a curriculum that requires each student to satisfactorily complete at least the following, right? One course of at least 2 credits in professional responsibility. We do that at King Hall. C, a law school shall provide education to law students on bias, cross-cultural competency, and racism at the start of the program of legal education and at least once again before graduation. I believe this racial justice speaker series is part of that, and the speaker series predates what the ABA has done. Most law schools don't have racial speaker series or requirements that would introduce students to the legal education that focuses on bias, cross-cultural competency. So as a dean now, I wanted to, I saw my project in a different light. I see it as part of the goal of legal education to help students, law students, in helping them develop professional identity and obligations to serve clients, to ensure that legal education includes a focus on cross-cultural competency and racism. The opinions that you read in your constitutional law classes, in property law, I teach property law, and many other 1L classes, right? Many of those are infused with language that would embarrass many of us today. And they are there, they've been edited out for the most part. But we need to talk about them, in my mind, in order not only to meet the ABA standards, but more importantly, to help law students become the ethical lawyers that they ought to be and develop this professional identity that will be consistent with your obligation to represent your clients. So ABA Standard 303 has an interpretation that talks about, that further explains this cross-cultural competency and professional responsibility. And notice that it says that it highlights the obligation of lawyers, right, to promote a justice system that provides equal access and eliminates bias, discrimination, and racism in the law. And so with this new standard gives meaning to some of the work that critical race theorists and all other legal scholars who engage in this area, including the rewritten opinions and judgments and projects that many others are engaged in. So here are just some of cases and case books now that have come out regarding rewriting legal opinions. Critical race judgments is the one that I mentioned earlier that has Che Chang-Ping in there, and that was where this case, Downs versus Bidwell, was supposed to be included. But no, and this is just some. I'm sure there are many others. I just couldn't fit them into one slide. Okay, so here then I'm turning into the second part of the talk, and that is why rewriting Supreme Court opinions. And I highlighted here one of the quotes that appear in critical race judgments. As the editor said, by rewriting U.S. Supreme Court opinions that implicate critical dimensions of racial justice, critical race judgments demonstrates that it's possible to be a judge and a critical race theorist. Now, some of us might not all agree that is possible, or that maybe that it should be possible. That maybe some might say that this is not the work or the role of the judge, right? But among the scholars that I wanted to work on in this project, we thought it was important to reread an opinion and figure out if we were at the time, if we were behind we were listening to oral arguments and then go back to chambers and imagine how we would draft our opinions. We wanted to see how we can write an opinion absent all the racist language that appeared in some of these opinions. For my purposes, rewriting opinions as a pedagogical tool is also important for a comparative purpose. So in my class, in my immigration law class, I've assigned Che Chang-Ping as the edited version that appears in an immigration casebook that I use, with the rewritten Che Chang-Ping that I've written. And then I've asked my students to compare, how do you think the result is different, and if so, what was the legal reasoning, and do you think it was possible for this opinion to have been reached in the way that I wrote it up? And so rewriting Supreme Court opinions from a pedagogical perspective allows students, in my view, to engage much more critically about the text, the purpose of the text, the legal reasoning, and how to apply the rule of that case, right, to new set of facts. And then lastly, in my view, rewriting Supreme Court opinions helps us to reimagine what the world could look like. So this is the normative part of the project. How might these cases, in their rewritten or reimagined form, help us to change the legal landscape, right? That is absent of racism and racial subordination. Okay, so with that, let me turn to why Downs versus Bidwell. Okay, Downs versus Bidwell was a 1901 opinion Has anyone heard, or not the law professors, you can't raise your hand. Anyone else heard of Downs versus Bidwell? Oh, okay, great. Where did you hear the case?
Just in a interview or podcast about kind of the insular cases and cases talking about citizenship in the United States or lack thereof for territories.
Great, great. Okay, thank you. Yes, there's a case, what I mentioned earlier, the Cuison-Villazor case, the 10th Circuit just had issued its opinion, and there is a cert petition that is before the U.S. Supreme Court. The insular cases have recently been in the news because of Puerto Rico, right? So there's a citizenship question, but also because Puerto Rico was recently hit with a hurricane, and that's not the first time, right? I mean, it's unfortunately, it happens regularly in that territory, and has shown that the impact of those hurricanes have wreaked havoc in their economic and political conditions. And there were a number of important cases that came up before the court the last 2 years. But for me, for my purposes, Downs versus Bidwell is part of the development of the United States as an American empire. This is a political cartoon that appeared in the early 1900s that critiqued the United States and the treatment of this country of several U.S. territories at that time: American Samoa, Guam, Hawaii, Philippines, Puerto Rico, and the Virgin Islands. And you can see some, and just using political cartoons as a way of understanding what happened at that time, you can see the kind of the cartoonist view of the political subordination that they saw against these particular countries. And notice that a member of an American Indian tribe is represented right at the door, and then the Chinese immigrant is also outside the door, right? So in this cartoon, one can see how racial subordination was operating, not through immigration law and also through empire. Downs versus Bidwell was the fifth of a line of cases that became known as the insular cases because they dealt with the insular territories. And so I've just listed them for you. I'm happy to share the slides later to whoever who wants them. But, oh, actually, that's not right. Downs is the fifth. I'm missing a case. And the reason why Downs versus Bidwell, to me, makes sense to talk about to engage in the rewritten perspective is because of this case that I mentioned, Cuison-Villazor versus United States. And here, and I'm going to foreshadow what I'll be talking about later, but Mr. Cuison-Villazor was born in American Samoa and then moved to Utah, and asked to, and as an American Samoan, he acquired what's called U.S. nationality, American nationality. So if you're born in American Samoa, you are not a U.S. citizen, despite the fact that it is a U.S. territory. Instead, people who are born in American Samoa are U.S. nationals. When they move to the United States, they can apply for citizenship, right? But to them, that is an insult because they've already been, they've pledged allegiance to the flag since they could remember. They serve in the military. And there's a big difference between being a U.S. national and a U.S. citizen. So I'll reserve the distinction between the two later, a few slides later. But Downs versus Bidwell helps to informs this case because Downs versus Bidwell was the most important of all the insular cases. Okay, so here's Downs. Downs was, the facts are, Mr. Downs was charged with taxes, import taxes, because he brought oranges, he imported oranges from Puerto Rico to New York City. There was a law, the Foraker Act, that said that goods and other products coming from the U.S. territories, including Puerto Rico, will be subject to an import tax, right? So Mr. Downs goes to New York City. The customs inspector said, "I'm going to tax you," and he does, and Downs sues, and he says, "Wait a minute, isn't Puerto Rico part of the United States? And if so, the U.S. Constitution says, Article 1, Section 8 says, all duties imposed and excises shall be uniform throughout the United States. So that should include Puerto Rico. He should not be subject to a tax, right?" So it was initially a constitutional question regarding the revenues clause, but it actually became bigger. The court saw this case as about whether the Constitution follows the flag, right? Because as I mentioned earlier, Puerto Rico, Philippines, Guam, American Samoa, Virgin Islands, and Hawaii were all U.S. territories. And at the time, it was unclear from the court's perspective how to treat these territories. It was not the first time that the United States had territories, and many other territories, Louisiana, California, right? There are a lot of other territories, but this is different now. And these territories are far away. They're populated by primarily people of color, right? Different from those in the United States. And so the court was faced with that question, how do we interpret the Constitution as applied in Puerto And so Justice Brown, joined by Justices Wise, Shiras, and McKenna, ultimately held that we are therefore of the opinion that the island of Puerto Rico is a territory appurtenant and belonging to the United States, right, but not a part of the United States within the revenue clauses of the Constitution. That the Foraker Act is constitutional so far as it imposes duties upon imports from such island, and that the plaintiff cannot recover back the duties exacted in this case. Okay, so the court upholds the Foraker Act and says, too bad for you, Mr. Downs. But then, ultimately, this holding sets up the framework, a strong framework for what has become known as this part that says appurtenant and belonging to, but not a part of. How can one belong to, but not be a part of, right? This became known as the beginning of the domestic, the insular cases, and the fact that the Puerto Rico and the other territories were known as domestic, but foreign, but in a domestic sense. So they're foreign in some ways because the laws such as the Foraker Act applies to them, but they are domestic because they belong to the United States. In this case, there were concurring opinions by Justices White, Shiras, and McKenna, and Gray. Okay, so I can walk us through some of the technical the legal reasoning of that case, but and I'm happy to do that at the Q&A. But really, my interest in Downs versus Bidwell was the court's specific use of language that, in my mind, clearly articulated why the court ruled the way that it did, right? And so I pulled some language from the opinion. It's 67 pages, which at the time I suppose was not that long, from a Supreme Court opinion. But here are just some parts of the opinion that stood out to me. Citizens of the United States discover an unknown island peopled with an uncivilized race, yet rich in soil and valuable to the United States for commercial and strategic reasons. Those possessions are inhabited by alien races, differing from us in religion, customs, laws, methods of taxation, and modes of thought. The administration of government and justice, according to Anglo-Saxon principles, may for a time be impossible. And this last one, really gets at me because of the work that I do in citizenship. Island inhabited with people utterly unfit for American citizenship. Right? So, as I dusted off this project and I tried to, and in rewriting it, these words truly emphasize just how this particular opinion, in ruling that the people in Puerto Rico are foreign and yet domestic yet foreign, shows exactly, in my view anyway, what the court had in mind. That because they were different people that were not that were not fit for citizenship, they could be treated differently. And so, as a result, I thought this is Downs versus Bidwell is perfect for what I'm thinking about in terms of rewriting it. So here's where I begin the really beginning part of this project. We're returning to it. Here are just some initial questions that I'm thinking of, and would be eager to know if there what your thoughts are about other questions that you think ought to be asked. So first, whether the United States Constitution should apply in the U.S. territories, full stop. Is that should we just do that, right? It's not that easy for me to answer, and here's why. Having grown up in the CNMI and gone to other U.S. territories, they don't have legal representation in Congress, right? It's that they have non-voting delegates. They don't have senators, and they can't vote for president. So to me, I'm trying to struggle with the idea that on the one hand, I want all laws to apply in full, but on the other hand, they don't have a voice in many of the application of those laws because they weren't part of it. They're not able to participate in any possible constitutional amendment that might happen. They don't get to vote for elected leaders whose decisions impact their territory. So I'm still trying to figure out how I can balance how I can fully address this question without engaging in any kind of racist language, right? We remove the racist language and then we have the question, should the Constitution follow the flag? And I don't know yet what the answer would be. Second, and that relates to the second point, how to address the rights of people in the U.S. territories that are not destined to become states. Puerto Rico is probably the closest one that can get to becoming a state, right? So some possible suggestions have been, how about if all the other territories plus Puerto Rico all gang up together and they will form the 51st state? Maybe that would be it. But that's putting millions of people together who are different. And so from a political perspective, is that really the right choice, given the diversity of the people that occupy those islands and territories? And then the third question in my mind is, in writing this, what approach would make sense? An originalist versus textualist versus maybe contextual living constitution approach. And so I'm trying to figure out what would be the best mode of applying these modern day approaches to in rewriting the case. I should have mentioned that there were, Kevin, I don't know if you followed this when you wrote your piece, but we were told that all laws still applied. All the cases, we had to rewrite, but still with all cases still applicable. So we couldn't just make up stuff, right? We couldn't. But, in reading some of these cases, they made up stuff. They made up Downs versus Bidwell. It came from nowhere. So then I remember thinking, well, if they could make up case opinions and principles, then why couldn't I do that? But that was the rule. We were still bound by precedent because we're lawyers and we follow precedent. And so with that in mind, I still have to think of the earlier insular cases and how those cases will shape my rewritten opinion, right, without any kind of a tinge of racial subordination. Okay, so I would like to pause here because the next one will be about the contemporary implications and the case study. Assuming I am able to rewrite the opinion, then what difference does it make, right? It's a big so what. So what then? If I rewrite it, what impact would it have on this case that might go before the U.S. Supreme Court, or even if it doesn't, how could it have changed if they had a different Downs versus Bidwell? But that's a different turn now in the discussion, and I just want to preserve the time that we have for a little bit to talk about the general project itself and to see if there are any questions from the audience. Yes.
Thank you. Just a quick clarification. When you're rewriting the opinion, are you maintaining the holding and just removing overt racial language, or are you kind of applying a critical perspective and removing the kind of implicit subordination and applying the critical race theory?
Yeah, great question. So in case, I don't know who's in the on Zoom, but the question is whether in rewriting the opinion, can we, now, the way I'm paraphrasing is basically, can we change, can I put on my CRT hat as a justice and then write it from my perspective, right? Basically, that's it. And yes, I can, so long as I'm still able to follow the other precedent. But it doesn't have to remain with the original author. So what I started doing in my rewritten opinion is Justice Harlan, who dissented in a related case, how maybe he could be the author of this opinion. Justice Harlan has, there's some problematic language that he also used in some of the opinions. So I need to contend with that. But that's how. So one doesn't have to be. It doesn't have to be the same author because I have to read what they wrote before in order to make sense of their opinion in this. Or I think some of the other authors decided to just pretend that they were on the court, and so then that was their intervention instead of. They became Justice Bennett Capers instead of the justice. And I don't know if what did you do, Dean Johnson?
I became Justice Sotomayor.
Okay, yeah. So
Arizona versus United States.
okay, yeah. So you can do that. But the original rules were we were supposed to be in the mindset of the justices who heard or who may have heard the case. Yes.
In question 1B2 questions, the answer to your question is whether the U.S. Constitution should apply fully in U.S. territories. You could say yes, but then the question is, does the Constitution require, for example, the same Social Security benefits in Puerto Rico as in Virginia?
Mm-hmm.
I mean, because you could say the Constitution applies, but maybe you might apply it differently in a territory versus a state.
I suppose, but then you have to get into the question of why treat states different from U.S. territories, right? So then if we are to say that the Constitution and all laws, federal laws apply, then in full, then they have to be the same no matter what. But I suppose one can say aren't there some differences in laws? In Hawaii that has a higher cost of living, aren't some laws different or regulations are different? So it could be through that process that one can make some distinctions that don't have an outcome that lead to lower Social Security benefits, some healthcare benefits, and a lot of other other benefits that people in the U.S. territories don't enjoy or are unable to enjoy because of their status.
Yes, just following up on Kevin's question. So I'm wondering on the first question, sort of what exactly it means to fully apply. And I'm thinking in other territories at the time of Downs would have been Arizona and New Mexico, where I think we would say the Constitution applied in full, but at the same time they didn't send representatives to Congress either because they were a territory, they were a different status. And so what exactly would it mean for that to fully apply, or is there something in this distinction between incorporated and unincorporated territory that flows out of this?
Yeah. So actually, that's a great point about how there were other territories, including Hawaii, and Hawaii became a state, right, a few decades later. But they were treated differently. They were treated closer to Arizona than they were to Guam and the Philippines and Puerto Rico. It's that incorporated, most likely to become a state, incorporated versus unincorporated territories that I will need to contend with. So the court in the insular cases said there are just some territories that are going to be incorporated into the United States, and so the Constitution applies to them, even though they were just U.S. territories still, right? By contrast, there are territories like the Philippines, Guam, Puerto Rico, that were not going to be incorporated. They already knew at the time that they were not destined for statehood, and so a different set of laws had to be applied to them. So it's that dichotomy between incorporated and unincorporated that I'll need to, on the one hand, I'd have to say it shouldn't matter whether they are destined to become territories or not, right? But the challenge that I have is what I know today, in that territories don't have political representation. And so my worry is that if we were to apply the U.S. Constitution, including the citizenship clause, to them, right? That's the case that I'll be talking about next. Then you're imposing citizenship on people who might not want it, and I'm worried about that. As much as citizenship is a prized possession, I'm concerned about a full application of the U.S. Constitution could mean you're forcing it upon American Samoans when most of them don't want it. At least that's the representation that they've made before the court.
So this is a follow-up to both of these discussions, but I think it deals more with number 2 than number 1. And that is looking at how the United States dealt with Mexicans when California and New Mexico, Arizona were taken over. Fremont versus United States is a case in which the you basically treated whites as the minority among a bunch of Mexicans when they were trying to figure out land grants, right? So I think there's language in there, and that's an 1850 something case. There might be language in there, right, in which you think about, that's exactly the same thing, right? But it's not, you're not dealing with the incorporation versus unincorporated territories. You're dealing more with what do you do with now a group of people who you've taken on as citizens, but they still adhere to the laws of Mexico and Spain.
Okay, all right, Fremont, I'll get
Fremont
the,
versus United States.
okay, all right. Thank you, that's helpful, and it is important for me to look at other cases, right? And how the Supreme Court addressed similar, unrelated, but sort of around the same time and the same project of what was racial subordination looking like at the time, what language was used in some of these opinions, and compare in order to come up with with an opinion that I just don't want to make it up. I want to be consistent at least with the cases at that time, even though the project is really about making stuff up. I know it's a lot of do I make things up or not, but I'm being thoughtful about it because Downs versus Bidwell and the Insular cases are relevant today, and they impact millions of people. They've impacted the lives of many others throughout history, and so we need to. It's important to talk about them for those reasons. Yes.
I was just going to make one point about 3, since no one's talked about 3. I think, and Carlton could correct me if I'm wrong, but I don't think there was an originalist approach to constitutional law really until the 1970s. So, you know, if you want to be historically accurate, you should sort of take that approach. Depends, you know, on the other hand, you should feel free, it seems to me, to take whatever approach makes the most sense to you. And it's going to be hard for you to recreate exactly what the mindset of I mean, it's one thing to follow precedents, it's another thing to abandon your whole analytical framework.
Yeah. Yeah.
So, but just a warning about originalism.
Okay. Thank you. That's really helpful. Oh yes. Hi.
This is a little bit off of your list, but you know, obviously the question of statehood is at the center of so much, you know, questions 1 and 2. And I'm wondering to what extent you've considered grappling in the opinion with the issue of why statehood has been taken off the table for the territories in question. I don't know to what extent it actually will inform. It might inform your answer to question 1, as in if statehood has been taken off the table for reasons that have nothing to do with the will of the people in those territories, then perhaps there are, obviously this would be an extra constitutional question, some equitable reasons for thinking about the ways in which the U.S. Constitution might be something we ought to apply fully in those territories, right? Because they are in this sort of limbo, right, where they don't have all the rights that the rest of us have, but they are effectively fully under the jurisdiction of the United States. And the question of statehood not being addressed seems to be one that potentially skews in favor, in my view, of applying the Constitution as a remedial solution to the fact that statehood itself is not actually on the table.
Okay, that's really helpful. Thank you, and it's a great question that raises that takes into account also what residents might be thinking, and specifically here Puerto Rico, right? It's not necessarily clear yet how a vote would take place, what the result would be if they were to vote now. Some say that now many of the voters will likely choose statehood, but we don't know yet. And so, but looking at this from that perspective of whether, if statehood could still be on the table, then does that change the analysis in some ways? This reminds me too of how some states, their population is a lot smaller than Puerto Rico, right? Puerto Rico has millions, and compared to, there are I think 3 or 4 states that have smaller populations, and so population can't be the reason why a particular territory should or should not be on this path to statehood.
Can I make one more observation?
Yeah.
So the other thing to think about also is, just putting myself back in 1901, the incorporation debates were yet to come too. So the idea, if the Constitution fully applies, that means they apply to the federal government there. They don't apply to the territorial government, right? Right?
That's right.
Everybody? Okay.
Yeah, what was the
So-
case, the DC case, is that, I'm
Well,
only talking about the
it was
14th
selective
Amendment.
incorporation and it took place over a number of years. I don't remember when it started, but, and I think some people sort of trace, hasn't like Christina Rodriguez talked about the insular cases as the beginning of sort of the incorporation debate, I want to say?
Yeah, she wrote a really helpful and a great article on this. Christina, no, actually, I think it might be thinking about Christina Ponza. And it's, yeah, the two Christinas. Yes.
So I was going to say, so corporation, I mean, the territorial government is an instrumentality of the federal government, so it's bound by the Bill of Rights. I mean, that's Fred Scott even. And so one of the issues here is if the territories have full constitutional protection, you get full Bill of Rights protection against your territorial government, which if you live in a state, you're not getting, because it hasn't been incorporated against states. And so that was one of the reasons they were somewhat hesitant to extend full protection to the territories, because then you actually have more rights, arguably, than would a citizen, say, living in New York.
Thank you. That's helpful. So, I mean, just to return to the piece that you're referring to, Bill, there was a case in 1925, and in that case, there were the court filings were rich with a lot of the incorporation debates that took place by that point. But the incorporation, the territorial incorporation doctrine that emanated from the insular cases were part of already during this time, in the late 1800s and 1900s, part of the political discussions that were happening. And so they all happened at around the same time and then fully developed, so that by 1925, in the case of Toyota versus United States, the court also then had to address what to do with the status of people coming from the Philippines, and particularly what their political status should be, whether they were they were U.S. citizens or American nationals. So that actually brings me now to the case that I'm going to examine in applying a rewritten Downs versus Bidwell. So in the Fides and Manu case, as I mentioned earlier, American Samoans are born as U.S. nationals instead of U.S. citizens. On their passport, their passports say that the bearer is a United States national and not a U.S. citizen. It looks like a passport otherwise. I wanted to highlight that many of the earlier U.S. citizenship claims were actually brought by Filipinos when it was a U.S. territory and then subsequent to becoming a U.S. territory. The insular cases, the Ninth Circuit and all the other courts, here they are, that dealt with this question, whether the citizenship clause applied in the Philippines when it was a U.S. territory. These courts said, and I'll go back to this slide here, that said that the Philippines were not, they were not part of the territorial scope of the phrase the United States, because the Philippines were not a state, they were a U.S. territory, and so therefore, in very specific provisions of the Constitution that was being examined, and particularly the Citizenship Clause, the court said that because the Philippines, although subject to the jurisdiction thereof of the United States, the Filipinos did not, the Citizenship Clause did not apply to them, to that territory, because they were not part of the United States, right? So one thought, it was a case, I think the most recent case was in 2009. That was the last time, yeah, the Lucidene case, where the question of whether the Citizenship Clause applied to the territory, that was the last time it was addressed by a court. But then there were other cases that were brought before the federal courts, and this time by American Samoans. And here, one of those cases is the Fides and Manu case, in which Utah residents argued that they should be considered citizens of the United States under the Citizenship Clause. And here the district court held yes, just using straight up Wong Kim Ark versus United States, and that was a Supreme Court case that said that if you're born in the United States, you acquire U.S. territory regardless of your parents' nationality, nothing like that, right? It was just you're born here on the soil, you're a U.S. Citizen. And so the district court in 2019 held that the insular cases were not controlling. What was interesting to me was that the American Samoan government and the congresswoman, the non-delegate, the representative that didn't have voting rights, but still a congresswoman, moved to intervene in the proceedings. And they argued that it should not be, the Constitution should not apply. They believe that it should be Congress. Congress should have the authority to declare whether the people of American Samoa are U.S. citizens or not. So completely taking away, right, the force of the U.S. Constitution in a U.S. territory and instead leaving it up to Congress. Congress does, under Article 1, has powers over the territories and American Indian tribes. So this was not the first time that the American Samoan government did that. There was another case in which they did the same thing. And to me, it presents an issue for how I will rewrite my opinion. Because I want to be respectful of the people of American Samoa, right? But at the same time, how do I address the application of the Constitution and my desire to have them be uniform? And so this is one of the pieces of the puzzle that I need to figure out. Okay, so the 10th Circuit held that the court did not rely on the insular cases, recognized that the insular cases are controversial, but instead the court decided to hold that the citizenship clause does not apply to them. It was a textualist approach that the court used without relying on the insular cases. But still, the insular cases remain in the books. They are valid. They're good law. Downs versus Bidwell remains one of the strongest or the most important of these cases. And so I'd like to figure out how to rewrite the Downs versus Bidwell and have it be meaningful for the case that might end up before the court, but if not, would have some impact on the Fidesamano case. So with that, I'll end, and I have a few minutes for Q&A. Thank you. So no cases on the American Samoa case. Oh, questions on the American Samoa case. No?
I have one question. Sorry, Cuison-Villazor.
It's Professor Socek.
Apologies. So in the last slide, with the interveners, they would like it to be in control, under Congress's control, and then what follows from that?
So,
they're not representative.
Oh, okay, great, thank you. So, presumably, the American Samoan representatives of the American Samoan government would get to sit down, have a seat at the table, and be able to negotiate with the United States government what their political status or membership would be. In the same way that the people of the Northern Mariana Islands had the opportunity to talk about what their membership would look like. And that membership is actually different. They are U.S. citizens, but there are some protections for their land ownership rights. So that in the Mariana Islands, through the negotiations, the people of the Mariana Islands were able to pass these protective laws for indigenous people, that only indigenous people can own land. So in this, if they're right, then we would think that Congress would create a space for that kind of a negotiation. But what that means is that we're accepting that the Constitution does not apply in full, right? It would so either, and is that where we need to be? I mean, I think that's a question. Should it be a binary if it applies or does not? And in my writing, in the last piece I wrote, Rejecting Citizenship, I said there has to be space for these kinds of conversations to have, because if they had political discussions in American Samoa, and they the residents asked, do you want to become U.S. citizens? And they said, no, we don't want to be U.S. citizens. We might not agree with their reasons for doing so. They're concerned that citizenship will impact their land rights. I don't think so, but who am I to say that they're wrong, right? I'm not from there. And but the bigger question is, if we are to support, if my project is about undoing racial subordination, shouldn't that include respecting what the people want, even if it means going back to the ultimate question, whether the Constitution should apply in full to these U.S. territories? So it's become far more complicated because of the position that the American Samoan government has made. If there was no question that they all wanted it, then I would have felt like, okay, well, let's apply it in full. What's the harm?
So if the court ruled for American Samoa, do you think it would also, by logic, then extend to persons born in the Philippines during the period of U.S. control?
Yes, that's what I'd like to say.
So it actually
Yeah.
would have that thing.
Yeah. There was language in one of the opinions that said the Philippines were different. But it's true. If the Constitution applies to them, then all those cases that I listed, then we ought to be able to go back. My grandfather was an American national. If he was a U.S. citizen, then it would have flowed all the way down to my family, and we wouldn't have to naturalize, right? But so I think the question with the Philippines is there are people who wanted to remain in the United States, and then some of them got deported because they lost their national status. They became non-citizens. So there's the question of the rights of Filipinos in the United States, and then the right of the country to decide for themselves what status they want. And from a foreign policy perspective, we would want the United States to respect what the Philippine government wanted, right? Even if it impacted the people who are already, the Filipinos who are residing in the Philippines. So it's complicated, but I think from a legal perspective, we could say, yeah, it has to apply also to Filipinos.
Hi, I'm just going to preface this with I'm a 1L, and so I don't know when I have my 2 Civ Pro contracts with professors.
Yay.
And I come from a Asian American studies background, so I feel like I'm leaning more towards this humanities perspective than a legal, so I'll preface that with this. But I'm wondering if there is room and how there could be room for a conversation about a colonial power dynamic. Like, at the end of the day, a lot of, I'm thinking specifically of Puerto Rican nationalists, such as Lolita LeBron and the lipstick revolutionaries, and kind of to give room to talk about America could be viewed as a colonial power. I would argue they are as a colonial power in context to this and kind of colonizing these countries and populations without a form of reparations, and I feel like that's what you're kind of pointing to in respecting people's opinions about statehood in the country, because they didn't respect it at the beginning, right? Isn't that why we're here now discussing this? I think I'm wondering where that conversation is positioned in context to all this. But.
Yeah, I love that. I thank you. Think to consider from a reparations perspective where that might fit in here as an approach to addressing both historical political violence, right, to ongoing imperialism, at least as applied to one might say applied to American Samoa and Guam. I wouldn't say that would be the case for the Mariana Islands because they had the opportunity to sit down and negotiate a covenant, an agreement. But I appreciate that, and I in my work I include interdisciplinary approach. I think it's important for us as legal scholars and as lawyers to continue to see the broader political, historical context that animated some of these decisions. So I think we're out of time. In just the 1 minute, I want to say, then I should have said this in the beginning, October is Filipino American History Month. And that's also why I decided to, when Dean Johnson, I was supposed to come in April, but I had to reschedule, and I said, can I come in October instead, because it's Filipino American History Month. And part of this project is really dedicated to that and expanding further Filipino American studies, Asian American studies, and the law. And so I really appreciate your time, your questions, and your engagement with me. I will be thanking UC Davis twice in my footnote because I presented an earlier version of this back in 2016, and many years later I'm back. So thank you so much for being here.